The building, which served as the Region 4 vote tabulation center during the last elections, has repeatedly surfaced, detailing alleged irregularities. The court-sanctioned exercise, known as a locus, is scheduled to allow several witnesses to revisit the site and physically identify the position of individuals involved during the critical incidents. Prosecutor Darshan Ramdani made clear that the visit is not meant to introduce any fresh evidence. Instead, it will be used to help the court better understand and visualize the testimonies already presented by eyewitnesses. The locus is expected to support the court's assessment of key moments during the tabulation process, which he reminded a flashpoint in the ongoing trial.
There were indications from the defense team that they had wanted a visit in court even before this trial had begun, but that could not happen because locus or a visit to the scene of the alleged crime has to be done in a particular way. Now that the prosecution has led a number of witnesses who say, among other things, that they are sitting, standing at various places in the building where the elections counting was being done, the validation exercise.
Tensions rose in court on Monday as defense attorney U.C. Anderson raised objections to elements of the upcoming site visit to the Ashmins Building, parts of the ongoing trial surrounding alleged electoral fraud during the 2020 elections. Anderson argued that neutral observers, rather than the prosecution witnesses, should carry out the pointing out exercise at the scene. He also took issue with the prosecution's request to have a police videographer record the visit using official equipment. However, Magistrate Faith McGusty dismissed the request, firmly ruling that only those witnesses who have already given testimony will be allowed to participate. She emphasized that the site visit is an extension of the prosecution's case and must be limited to individuals with direct first-hand knowledge of the events. The court has yet to rule definitively on the videography issue, though objections from the defense remain on record.
There was a suggestion, or a statement rather, by one of the defense lawyers that they didn't trust. I believe this is what they said. If I'm mistaken, I stand to be corrected by the record, that they didn't trust the Guyana Police Force to do this. Now, we of course responded to that in court, and we said that a defense lawyer's own personal views, about his feelings about a law institution of the country is immaterial to the case. Lawyers can't stand and give evidence of the views of witnesses or the prosecution witnesses. They can offer the court a thought in closing that we would ask that the court find that a witness is not credible. But to stand during the course of a trial and to make a statement that you don't trust the Guyana Police Force.
Proceedings in the ongoing election fraud trial case was briefly disrupted on Monday when Carol Smith Joseph, a key defendant in the matter, interrupted the court with what was described by the chief magistrate as an outburst. Magistrate Faith McGusty halted the session to restore order, issuing a stern warning to Smith Joseph and reminding the court that decorum must be upheld, particularly during procedural matters being addressed by the bench and attorneys. The magistrate also addressed her remarks to defense counsel Majlie Hughes, Smith Joseph's attorney and presidential hopeful of the AFC, noting that no further disruptions will be permitted as the trial continues. Colwyn Abrams, TV9 News.